Good afternoon, everyone. Welcome back to the second half of our America Invents Act Roadshow. Thank you all for returning from lunch. Hopefully you have more sustenance and are ready to learn about more of our proposed rules. This morning, we spent time talking about the patent-related provisions of pre-issuance submissions, inventor's oath and declaration, citation of a patent owner's statement in a patent file, and supplemental exam. Now, this afternoon, we are going to talk about the new trial proceedings that will be available before the Board of Patent Appeals and Interferences. Incidentally, the board's title will change on September 16th of this year from the Board of Patent Appeals and Interferences to the Patent Trial and Appeal Board to accompany the new trial proceedings that the board will be conducting. So as we're going to proceed the same format as this morning, the presenters will go over a series of slides to introduce for you both the statutory provisions, which will be featured in black font, and the proposed rule provisions, which will be featured in blue font, so you can distinguish between the two. We will start by talking about the specifics of the various proceedings, and then we will move into the umbrella rules, which I had likened to the rules of civil procedure. So joining us this afternoon for these presentations about the trial rules are two judges from the Board of Patent Appeals and Interferences, Judge Mike Tierney and Judge Sally Medley. Judge Tierney is the lead judge of the trial section of the board. Prior to taking that position, he served as a judge in the interference and contested case area for several years. He was also a patent examiner and worked in private practice. Judge Medley is the former head of the trial section of the board, and she, like Judge Tierney, was also a patent examiner, a primary patent examiner in the biotechnology unit before joining the board a few years ago. So they are going to walk you through the provisions this afternoon, and I encourage you, just like this morning, ask questions, give commentary, but when you do so, please be sure to come to the microphone so our web audience can hear you. And for our web audience, I encourage you to do the same about asking questions, but you will be submitting the questions through the web chat using the host as your contact. So with that, I will turn things over to Judge Tierney to get us started.
Welcome, everyone. It's nice to see we have a pretty full room today, and I expect we'll even get a few more in here. I just want to say that we're very excited about these changes, and we're going to walk through them today. We have a lot of information we're going to cover. We will be going pretty high level, but we'll also have time for questions at the end. So if you want to get into the fine details, feel free to bring up your questions at the end of this. And we'll actually have a first part, a session, where I'll begin and explain what we're going to do. We're going to talk about just a general overview of the AIA as it pertains to the board. As you can see, there are going to be 4 new proceedings that the board will be handling. So I'm going to give an overview of the AIA, and my colleague, Judge Medley, will go into the proceeding-specific rules. And those are rule packages designed for only those specific proceedings. We'll take a break at that point, and after the break, we'll start off. Judge Medley will give a presentation, then we'll actually take some time for questions. We'll have a quick break, and then we'll come back and we'll get into the nitty-gritty of the umbrella rules. I'll take a moment there why we have something called Umbrella Rules and Practice Guide. Well, as you're probably aware, we have 4 new proceedings, and we had to create rules for them. The proceedings, as we're going to see right over here, there's going to be, we'll talk about considerations. There's actually quite a bit in common among all these new proceedings. So when we created the rules, we decided, do we want to create 4 sets of rules with a lot of commonality, or do we want to create just one set of common rules that everyone can read and understand, from which you can then take a case on IPR, which is inter-party review, on a Monday, pick up a post-grant review on, say, a Wednesday, and only have a small set of rules that would be different. And all the rules in common you already know, so you don't have to relearn the wheel, basically, or reinvent the wheel, as we would say. So what we've done, going back here, we've created an umbrella rule set. We've also, if you haven't had a chance to read the rules, we know there's a lot of pages to our rules. We created a practice guide, and if you haven't had a chance to look at our rules yet, I suggest you begin reading the practice guide. That's setting the high level of how we're going to conduct these proceedings. And it also gets a little bit more flavor about these rules. We've heard sometimes people find rules to be dry. Hopefully the practice guide will give it a little more life and meaning, as we would say. So that's what we're going to be covering today. Let me just talk a little bit about how did we go ahead and formulate these rules in the first place. Well, Congress basically told us there are some things we have to take into consideration. So it wasn't just with a blank slate we went ahead and created these rules. Congress has specifically told us, and as we put up here, 316, I just want to comment, 311 to 319, when you see those statutes, that's going to be the inter-party review statutes. In the 321 to 329 range, that's going to be referring to what we call post-grant review, PGR. So in the considerations in 316 for IPR and 326 for PGR, we are having to take into account the effect of the regulations on the economy, the integrity of the patent system, how we can efficiently operate the patent office with our rules, and also, not last but not least, timeliness of the proceedings. For as will be mentioned during Judge Medley's presentation, and even again during the umbrella rules, we only have 1 year from the date we institute a trial to run the trial to completion. There will be a good cause exception, but for these rules, we've designed them to try and get these trials completed in 1 year. And again, we do understand there will be exceptions, but the focus today and why we created the rules and why we're doing the rules in this way is we're going to streamline proceedings, converge issues, so that we are able to achieve the goal set by Congress of the 1 year trial. So the legislative history also gave us some guidance here. And what did they tell us in Congress? Well, if you look up here on the slide, we point out very easily, it's supposed to be quick. As I mentioned, it's 1 year from the date we institute a trial to completion. It's supposed to be effective. We're supposed to give a fair decision. And also, we need to be an alternative to district court litigation. As many people are aware today, litigation takes a little bit of time, maybe a little more than a little bit of money. So we're trying to be a little bit of an improvement upon that system. And I believe when you walk through the rules, and as we will today, you'll understand how we've taken steps to not just replicate what's in district court, but on a 1 year scale, but take the best parts of district court that we can and put them into our rules to have that streamlined proceeding, convergent issues till we get to a point of final decision. And the key today is converged issues. As will be mentioned later, when we institute these proceedings, we're not going to just institute on all the claims that we're bringing out in the petition. Only those for which these threshold tests we'll talk about have been met. And it's only going to be on ground for which the threshold's met. Again, every time we're talking today in these rules, think in your mind how we're trying to converge, focus the proceeding, give the definitive target to both the patent owner and to the petitioner so they know what's at stake here and what the focus is. Now, I mentioned briefly that what was that?
Ma'am, we were unable to hear you. Could you please repeat what you just said?
Okay, I guess someone was speaking in the back there, so.
Yes, this is a general conference. Please, if you want to use your cell phone, you can do so by the doors of the library, but please do not use cell phones in the room because we are videotaping and it will cause congestion with our taping.
Well, as I pointed out earlier, there's 4 new proceedings we're doing: IPR, PGR, CBM, we're calling it for covered business method, and derivation. And when you read the statutes, you'll notice a lot of commonality between the provisions. For example, each of these new proceedings begins with the filing of what's called a petition. So we get a request from a party, and it's going to be a third party. These are inter-party disputes. And then it's required that we have to meet certain thresholds before we continue on with the request. So petition filed, the board will look to see whether the thresholds have been met, and where it's met, we'll go on, again, claim by claim, ground by ground. We'll then conduct a trial on the merits. As you're aware, these proceedings are going to have discovery. So when you look at the statutes, you realize there's some flavor in it of ex parte prosecution. There's going to be an amendment, but also there's a lot of litigation aspects here. There's going to be discovery, motion to seal, protective orders. So it's really a hybrid here. We're not going to be exactly like a district court. We're not going to be like an ex parte prosecution. This is the hybrid between the two. So we'll conduct the trial on the merits. Final resolution will occur where it can be a termination, for example, a party settle early, or it's possible that we'll actually get to the hearing and have a final written decision. And we'll talk later today what the final written decision will contain, but you can imagine we have to determine patentability of the claims in the review. So basic terminology we want to cover today, just so we all are on the same page. It's very important to get that communication going. I've used the term proceeding. Proceeding is a generic term in our rules. It's the beginning of the case to the end of the case. And why do we choose that term? You'll notice our terminology is tracking that used by Congress. For example, in IPR and PGR, they go ahead and in 315 and 325 told us that proceedings includes inter-party review, post-grant review, business method, and also derivation. And if you look at the derivation statute itself, the title is derivation proceedings. So we've used that as our generic term. Next, we use the term petition to begin one of our, it's basically the request to institute these trials. Why do we use petition? Remember I said this is somewhat like ex parte, somewhat like district court. If you do ex parte prosecution, the word petition commonly is used to mean I want relief from a rule. Or an ex parte reexamination or inter-party reexamination, you're filing a request for a re-exam. You don't file a petition. That's more, I need relief from a certain rule. But Congress has told us in the statutes, 311, 321, et cetera, petition is a term used to start the proceeding. That's what you're filing, a petition that requests the trial. So we followed Congress's lead and use a petition only to designate that paper which is requested when we start the review. Next, I've used the word trial. And most people are familiar with the term trial in district court litigation, where the trial is before the judge and jury. Here, it's much more of what we call a trial, but in paper form. And we'll talk later. We do have the ability to do live hearings, but because of expense, we're trying to narrow the expense. We're going to do a lot of this in paper. But why do we still use the word trial? As Janet mentioned, we're the Patent Trial and Appeal Board. Congress changed their name to reflect that we're conducting trials. We're following what Congress told us. These are trials. Lastly, we're going to use the term motion today. The term motion is what most people are familiar with as a request for relief, other than a petition. So let's say you're in a proceeding and you find a rule or you have something additional that you need and you want to request relief on, you would have a motion. It can be as simple as just calling the judge in a quick conference call, having resolution in 5 minutes, 10 minutes on a decision. But essentially, I mean, that's all a motion is. It's a request for relief. Now, we're going to turn it over to Judge Medley in a moment, but I just want to point out one last thing, and that is we're very thankful we were receiving comments from the public and generating these rules. From their comments, if you track all the comments we received and match them up to the practice guide, you'll notice a lot of commentary has made its way into the practice guide. And in fact, because of the comments, we were able to see that some people wanted us to go left, some wanted us to go right in the areas. But by giving that information, we were able to try and find some common ground in development of these rules. So when you look at the rules, we're doing various things. We're trying to find a way to streamline the proceedings, converge the issues, but also balance the interest between the patent owner and the petitioner. Because we know they have different views on how things should be done. We're trying to find the middle ground and find a balance there. So in going forward, I'm hoping that we'll be able to see some written comments from people here and people in the future that tell us what areas do you think we've done things right, and also what areas, of course, we can improve upon. And we've received some already to give us guidance in how we can clarify rules or revise them. But keep in mind, we were talking to people, and they were going through point by point. They want to change this, this, this. Then you step back and go, well, what's your overall feel of the rules? And they go, overall, we had a good feeling. And my comment to them was, well, hopefully you would also point out those things you like. Because if all we get is comments saying we want changes, and you get a set of changes here, 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 and here, we might find out later, if we did the change, that there was a silent majority or people were actually pleased with the one proposed rule. And it was only like a couple comments on the side that told us to change that we listened to. So we want to try and have balance here. Again, we're trying to find that right spot between petitioner's interest and patent owner's interest and keep these a fair and efficient proceeding that streamlines the proceeding, converges the issues so we can accomplish this in that 1 year time frame. So with that, I'm going to turn it over to Judge Medley, who's going to talk about proceeding-specific rules.
Good afternoon. Thank you, Mike. Thank you, Janet. I will begin with an overview of the statutory requirements for IPR, followed by an overview of our proposed rules for IPR. And then I'm going to highlight the similarities between IPR and the other three proceedings, PGR, CBM, and derivation, and go over those proposed rules. And then I'm going to explain those differences. And I'm also going to review a proposed scheduling of events for the inter-parties review so that you'll get a general feel of how these proceedings will manifest. So, as they pointed out earlier, the language highlighted in black, that comes from the statute, and the highlighted language in blue comes from our proposed rules. And again, as Mike emphasized, these are proposed rules, so we'd love to hear comments from you, from the public. So why are we starting our discussion with the IPR? Well, these are the proceedings we expect to see first. The IPR statutes are effective September 16th of this year. At that time, the requests for IP re-exams will not be accepted. So if you were to file, for example, an IPR re-exam request on that day, the office will not accept it. But of course, all those IPR re-examinations that are in process up to that point will still complete those to finality. What patents are eligible? All patents are eligible for an IPR, both first to invent and first inventor to file systems. So this is somewhat different also from inter-party re-exams where you had I think November 29th, 1999 was the date forward from that, where you could challenge the claims of those patents. But now you can challenge the claims of any patent. So the pool is wide open. And of course, this is not an ex-party proceeding because the title tells us it's an inter-party review. So if you're a patent owner, you cannot file a petition in an inter-party review. You have to be a person who's not the patent owner and who has not previously filed a civil action challenging the validity of the claim of the patent. You can't file an IPR. Okay, so while the patent pool that may be challenged is very broad, since all the patents may be challenged out there in the sea of patents, the ground for challenging the claims of the patent is narrow. A petitioner in an IPR may request to cancel as unpatentable one or more claims of a patent only on a ground that could be raised under 102, 103, based on prior art consisting of patents or printed publications. And this is a difference and a distinction between PGR, which I'll discuss in a few minutes, which you have a much more broad base that you can attack the claims of a patent. And also, unlike PGR, where the window for filing is very limited, it's within 9 months of the grant of the patent, the window for filing an IPR is much greater. However, you must wait till the latter of 9 months after the grant of a patent or issuance of a reissue of a patent or the date of termination of any post-grant review. And now I'm going to discuss what you need to file in your petition and what requirements do you need to meet. There are several statutory requirements, and then there are, of course, some proposed rules that we have. The statute tells us that we must accept a fee. So you need to file a fee with your petition. You must identify all the real parties and interests. And this is important because, as you may be aware, estoppel attaches to these proceedings. And also, judges will be running these proceedings. So they need to know and be aware, too, of who the real parties and interests are because they may have conflicts of interest and they may have to recuse themselves. So it's important that we have that information. The petition must also identify all the claims challenged and the grounds on which the challenge to each claim is based. And this is our proposed rule. We propose that the petitioner must include a claim construction and show how the construed claim is unpatentable based on the grounds alleged. And again, the office, as Mike was saying, these are sort of hybrid proceedings. because they're like, we have many trial-like features with discovery and motions practice, but we're also considering patent owners' amendments to the claims. So there's sort of a hybrid between trial and examination. So the broadest reasonable construction rule will apply with respect to claim construction. The petition must also identify the exhibit number of the supporting evidence relied upon. And this is important in the inter-party reexaminations and ex-party reexaminations that we receive at the board. Oftentimes the record has several duplicate copies of the same exhibit, or they have 4 or 5 of the exhibit, and you don't know which exhibit is being referred to. So this might seem like a really minor point, but it really helps us when we know you're talking about exhibit X, that that's what we're to look at. And you're also supposed to state the relevance of the evidence. And this is also important. We expect you to direct attention to where in the record the evidence supports the argument. So it's not going to be enough to just say, here's my 5,000 pages of evidence, and here's my argument, and please try to figure out my case. I'd like for you to point out specifically what evidence supports your argument that you're making. And then the statute also tells us that we need to provide copies, or the petitioner needs to provide copies of the evidence upon which they rely. So what next? If these requirements are met, a docketing date will be given, and the parties will be notified, and a judge will be assigned and identified to the parties. The judge will assist in facilitating the proceeding, and this is an important part of this proceeding as opposed to other inter-party reexamination or ex-party reexamination. The judge is going to be assigned at the beginning and runs with the case until the end. So if there are any issues that come up, the parties have a dispute, or they have maybe a question for the judge, maybe there's a deposition and the witness is not answering a particular question the way they want, they place a call to the judge would rule right there on the spot and give you an answer. So you don't have to go through a lot of process of filing a paper or waiting to get a decision. You call the judge, and the judge will rule right there and memorialize it in an order within a day or two. So during the preliminary phase, the patent owner may file a preliminary response to the petition to provide reasons why no IPR should be instituted. And this response is due 2 months from petition docketing date. The response could be a simple statement stating that the patent owner elects to file no response, and no negative inference will be taken from that. The patent owner at that time could also disclaim certain claims. They might decide, well, these issues, some of these claims are more important to me than other claims, and so that would help us streamline and converge the issues, as Mike was saying, we really are trying to do in these proceedings. The general rule is that the preliminary response may present evidence other than testimonial evidence. Well, you may wonder, why is that so? Why can't I put out my first full case? I'm the patent owner, I need to protect my property, right? Why can't I go ahead and file everything at this point? Well, the reason is this is the preliminary part of the proceeding. It didn't seem to make sense to us to have a full-blown trial before we got to the trial. So you will be limited with respect to the kind of evidence that you'll be able to submit. So you may ask, well, what kind of potential preliminary responses could I file if I don't have full-blown evidence available to me? Well, you could make such arguments, for example, that the references are not prior art, or that the prior art lacks a material limitation that's provided in all the independent claims. Those are the sort of things that we would expect to see. Of course, there are exceptions to this provision, and testimonial evidence and discovery may be provided where necessary on a case-by-case basis. And we give the example of, for example, you may require discovery or that you want to submit testimonial evidence to demonstrate the petitioner's real party and interest is to stop from challenging patent claims. Because as you remember, that's starts the trial. That's sort of a basis you have to show that you aren't a stop before we'll even go forward. So that might be a situation where we would consider accepting testimonial evidence. Okay, at this point, the board will determine whether to institute within 3 months of the patent owner's preliminary response, or if no response is received within 3 months of when the response was due. So what does the petitioner have to demonstrate? Well, they must demonstrate that there's a reasonable likelihood the petitioner would prevail as to at least one of the claims challenged. And one of the differences between the standard here and the standard in PGR is that PGR, it's more likely than not. Well, I think all of us can agree, more likely than not is greater than 50%. Well, what does reasonable likelihood mean? Well, we didn't put a rule on it or specifically define it, but our understanding is that reasonable likelihood is that it's a close call, and the judge can make that call. What would be a close call? Maybe 49-51, 49 likelihood, 50-50, close. 20% likelihood, we would not institute in that situation because you've got a patent owner that you're bringing in front of the office and you're, challenging their property right. So it has to be close. Where the IPR standards are met, the board will institute the trial on a claim-by-claim basis and ground-by-ground basis. And this is also very important, we believe, to converge and streamline the proceeding so that everybody knows what's at stake here. We could have just said, well, you've made your case on at least one claim, we're going forward. But that doesn't really help because you don't know which claims are at stake and which grounds actually that you made your case on. So we're going to let you know up front, claim by claim, ground by ground, how we're going to proceed. A party dissatisfied with the board's determination may request reconsideration as to points believed to be misapprehended or overlooked. So if you don't agree with our determination to go forward in the grounds upon which we decide to go forward, you can request reconsideration. Also, if we determine not to institute at all, that's non-appealable and final, but we will consider a request for reconsideration. IPR trial is with the other three, PGR and CBM. They will be completed within 1 year from institution, except the time may be extended up to 6 months for good cause. And as Mike was talking, really that's the exception and not the rule. We really are going to try to get these things completed in 1 year. They're supposed to be cheaper. They're supposed to be faster. So we're going to really try to see that these are completed within a year. Having said that, there are circumstances where extensions of time would be, there might be a good story for that. But when we grant extensions of time, it's likely on a, day-to-day, week-to-week basis. We would rarely grant a whole 6-month extension. So it's case-by-case basis. Okay, at this point, the parties would be notified with the decision from the board to institute the trial, and the parties will also likely receive a scheduling order. And again, this is all highlighted in the practice guide, and I encourage you to read that because it really sets forth how a proceeding would lay out. So the scheduling order would set times for filing papers in the proceeding. A conference call will be held approximately 1 month after the institution of the trial to discuss the motions the parties intend to file and determine if any adjustments need to be made. And this is sort of what we envision. Again, this is in the practice guide. And before the patent owner files a response, according to the scheduling order, the patent owner will have opportunity to cross-examine petitioner's witnesses. Then the patent owner can file a full response at this time. Once the institution of the trial begins, it's approximately 4 months after institution of the trial. So as you remember, from the beginning of the entire petition phase, when the petition files the phase, up to the 4 months that you would have to file your patent owner response, it's about 9 months. So you have quite a bit of time to formulate your strategy think about what you're going to do. So a patent owner can file a response to petition addressing any ground for unpatentability not already denied. In submitting a response, the patent owner must file through affidavits or declarations any additional factual evidence and expert opinions on which the patent owner wishes to rely in support of the response. The patent owner may also file at the same time one motion to amend a patent subject to the standards and procedures set by the office. The amendments can cancel claims and or propose a reasonable number of substitute claims. And additional motions may be filed as authorized and necessary. So we get the question, what's a reasonable number of substitute claims? Well, that's sort of a case-by-case basis also. Certainly a one-for-one claim substitution, that sounds reasonable to me. But when someone asks for 10 claims, maybe for a substitute of one claim, that might not be reasonable. And you have to remember, we're trying to complete these within a year. So if we have, 10 claims for one claim and you had 10 claims, now we're looking at 100 new claims. It's really, really going to be difficult for us to finish the case within a year. So Congress has told us we need to get these done quickly. So we're going to really try to do that. So the motion to amend, it may be limited to that effect, to help us get to a conclusion fast. So after the patent owner files their response, the petitioner may file a reply to the patent owner's response and in opposition to any amendment filed by the patent owner. After that, the patent owner may file a reply to the opposition filed by the petitioner. And then other events would take place, leading ultimately to a hearing if the parties request it, followed by a written decision by the board. A party dissatisfied can appeal to the Federal Circuit. There is no district court appeal for IPR, PGR, CBM, the covered business method patent. Now, if you're dissatisfied with the derivation outcome, you can appeal to the Federal Circuit or to district court. So now that I've gone through in great detail with respect to the inter-parties review, I'm just going to highlight the differences for the post-grant review, the covered business method patent review, and then go into the derivation, which has its own sort of differences. Most aspects of the PGR and IPR are effectively the same. For example, you have to have your petition, and you have to have the requirements for a petition that you did for IPR. So you have to have your fee, you have to identify real party and interest, ID the claims, the grounds for finding the copies of the evidence, etc. The preliminary patent owner response would be essentially the same. It's limited, it's not open to full-blown trial. Patent owner response after institution, the requirements are essentially the same. And then the amendments would also be essentially the same. Reasonable number of substitute claims or cancellation of claims. So now discuss the differences between PGR and IPR. With limited exceptions, only those patents issuing from applications subject to first to invent to file provisions of AIA. So these statutory provisions become effective March of next year. So where I said earlier that the IPR pool of patents is wide as any patent out there, this is limited. It's limited to, with only a few exceptions, and we'll talk about covered business method patents because there you can file under a first to file or first to invent system. PGR allows challenges, however, based on 101, 102, 103, and 112, except for best mode. So the grounds upon which you can base your challenge is much, much broader here. PGR may only be requested on or prior to the date that is 9 months after the grant of a patent or issuance of a reissue patent. So again, the window of opportunity here to file is much narrower than with the IPR. Another departure is that the petition must demonstrate that it is more likely than not, which is a higher standard than, higher threshold than an IPR, that at least one of the claims challenged in the petition is unpatentable. And again, as I said, that's more likely than not. That's greater than 50%, and then we would proceed. The AIA also provides in Section 324B that the determination required under 324A may be satisfied by showing that the petition raises a novel or unsettled legal question that is important to other patents or applications. So that's another way you could get into a PGR. The transitional program for covered business method patents is just that. It's a transitional program, and I'll refer to that as CBM. The CBM takes effect September 16th of this year, and the provisions and regulations issued under the AIA will be repealed on September 16th of 2020 with respect to any new petitions. So this sunsets 8 years from this year. Generally, the CBM employs the PGR procedures and standards. And how do we know this? Because the AIA tells us this. Section 18A1 of the AIA provides that CBM reviews will employ the standards and procedures of PGR. And as you may be aware or noticed in our notice of proposed rulemaking, we only have 5 rules in the covered business method. And that's because we employ and use the PGR rules. So there's only 5 additional rules. So what are the differences between your standard PGR and a covered business method review? Well, the petitioner cannot file a CBM review during the time a PGR review could be filed, 9 months after issuance. So you have to wait the 9 months after the issuance of the patent. And the other major requirement here is that the petitioner must be sued or charged with infringement. This is, we believe, going to keep a lot of people from filing these petitions because this is a big hurdle. You have to be sued or charged with infringement. Another hurdle is that the petitioner has the burden of establishing that the patent that they are attacking is eligible for this covered business method patent review. So unless it's not a covered business method patent, we're not going to institute. And the petitioner must establish or certify that they are not stopped from proceeding. So we even have more differences here. Eligible patents must be a business method patent. So a CBM patent, what is that? It's generally defined, and Congress has defined it for us, as a method or corresponding apparatus for performing data processing or other operations for financial products or services. However, the business method patent definition excludes patents for technological inventions. And we have proposed a technological invention definition in a separate rule package. And this is because we realize that this is an important issue for a lot of people out there and that we were going to receive a lot of comments. So we kept it separate from everything else so we could receive the comments directed to that definition. So what patents are eligible? Of course, only covered business method patents, but both covered business method patents under the first invent and first inventor to file system are eligible. However, prior art is limited when challenging a first to invent patent. So on to the technological invention definition. A proposed rule, and again, this is a proposed rule, and we encourage people to let us know if they think this is a good definition or if they think they have some comments or suggestions. We would love to hear from you. Proposed rule provides that solely for purposes of a CBM review, the following will be considered on a case-by-case basis to determine if a patent is for a technological invention. It's a two-pronged test. It's whether the claim subject matter as a whole recites a technological feature that is novel and unobvious over the prior art and solves a technical problem using a technical solution. And there were many factors that we considered in formulating a definition. We looked at the legislative history, and we also considered comments that we received. So again, please comment if you have any, if you like the definition or even if you don't. So derivation. As you know, interferences will fade away. However, we will still have one component left, which is derivation proceedings. This is so because Congress has determined that the office will not award a party a patent based on misappropriation of another's invention. That just makes sense, right? You don't want to encourage that. So the AIA derivation petition requirements, they differ from IPR, PGR, and CBM in a couple major ways. The first major requirement is that the petitioner has to have an application before the office. Only an applicant for patent may file a petition to institute a derivation proceeding. So we envision that the petition will be filed during ex parte while the case is in front of the examiner. So this is going to be different. Likely won't come right to the board. It'll go to the examiner. And then generally we won't institute until the examiner tells us, yes, these claims are allowable, and now it's time to consider the petition. The petition must set forth with particularity the basis for finding that an inventor named in an earlier application or patent derives the claim invention. And the petition must be filed within 1 year of the date of the first publication of the claim to an invention that is the same or substantially the same as the earlier application's claim to the invention. So there are many requirements here when you file a petition, and they are as follows. You have to identify the application or patent for which a derivation is sought. You have to certify that the petition was filed within the 1 year time set by statutory requirements. Demonstrate that you as the petitioner, you do in fact have an application pending, and you, the petitioner, need to show that you have at least one claim that is the same or substantially the same as the respondent's claimed invention. You also need to demonstrate that the respondent's claimed invention is not patentably distinct from the invention disclosed directly or indirectly to the respondent. Certify that the earlier application was filed without authorization. Oh, I'm sorry, I'm not on that. Click over. There we go. Certify that the earlier application was filed without authorization and provide a claim construction for the disputed claims. Also need to provide substantial evidence, including one affidavit in support of the petition to show how the invention was communicated to the respondent. So it's going to be something more than just he said, she said. You need to have maybe evidence to show, corroborating evidence to show these events took place. As I said earlier, a derivation is unlikely to be instituted even where the director thinks that the standard for instituting are met, the standards are met, if the petitioner's claim is not otherwise in condition for allowance. I mean, that just makes sense. If you don't have a claim that's in condition for allowance, we're not going to drag down an applicant's claims or a patentee's claim. Action on the petition may be deferred until the petitioner's claims are allowed. And unlike IPR, PGR, and CBM, the parties to a derivation proceeding may resort to binding arbitration. However, the office is not bound by, and we may independently determine any questions of patentability. So this concludes our first session, and I believe this time we will entertain questions.
Thank you, Judge Netley. Questions from our live audience, please come to the microphone. To get us started, we have a question from our web audience. If a party is unsuccessful via a post-grant review, can the party then bring an inter-parties review, or will the party be stopped regardless of the new materials being submitted in the inter-parties review?
I just want to say, Yeah, that question is actually pretty clearly answered by the statute on this one point, in that if you look at the statute in 315E1, if you're in an inter-party review, was it inter-party review and then try to do post-grant or vice versa?
Post-grant followed by inter-party.
So then flip. 325E1 is a statute I would look at. That basically provides that for the office, if you're in a PGR, for those claims that are in the review, if you don't prevail, there will be an estoppel where we go to a final written decision. So I'm going to make some assumptions here on facts. Let's assume there is a final written decision in that post-grant review on particular claims. Let's say it's claims 1 to 10. If you then try to do a inter-party review on claims 1 to 10, you are going to be estopped on what was raised or reasonably could have been raised. So if you're merely bringing the same arguments in again, the statute provides for estoppel. But now if we change those facts just slightly so that you're now challenging claims 11 to 20, if those claims weren't part of the post-grant review, there would be no estoppel because there would not have been a final written decision against you on claims 11 to 20. So in that scenario, you see how you change the facts just slightly and you get a different result. So it's very fact-dependent, but clearly, if you had a final written decision on specific claims, what the statute provides is you cannot then come before the office for what was raised or reasonably could have been raised.
Yes, sir. Please come to the microphone to ask your question.
Mark Nelson. Two questions. One on the definition of technological innovation, which the office came back with terms technical solutions. Question, will you now have a rulemaking proceeding to define technical so that we won't have a circular definition? If you probably will define this technological, I think that circle will be complete. So I don't fault the office of coming with a definition of circular. It's probably Congress's concern in terms of defining it. I cannot imagine any invention for which a patent is filed that is not a technical solution. I'm not sure you can get a claim on something that is not a technical solution. So to me, that's the first question of the scope of that definition. Number two relates to derivation. There are now, under 102, evidence that can be brought to bear from all over the world. In derivation and in PGR, there might be sources of evidence, testimonies, and things like that we may need to compel discovery across the world. Is there any thought through the process of rules of evidence that you considered to enable those who are being challenged with evidence from testimony or evidence from around the world to actually compel discovery in other jurisdictions? How would that happen? Third part of the... How
about just one question at a time for our panelists? They're taking notes already, so one question at a time. So let's do the technological invention question first, please.
Okay.
I can take that one. You asked if we had plans to define technical, and at this point, no, we don't. I mean, this is going to be a case-by-case basis.
Couldn't you have done that with technological? Case-by-case?
Actually, this is Judge Chair. I just want to point out this is obviously a very difficult question for us. We've had a lot of discussion internally how to proceed on that definition. But let's back up and ask ourselves what we're trying to do here. This is a definition not of necessarily 101, because if it were a definition of 101, then it wouldn't be a covered business method review with looking at 102, 112, 103, but it would merely be a 101 review. So it became a little bit difficult question as to how we define it so that it is looking at technological invention, but it's not exactly identical to a 101. So we considered many different sources, and what we did consider, especially, we looked at legislative intent, we looked obviously at Bilski, we looked at various areas. And what we found among the various different opinions was basically, if you look at Bilski, we recognize these are taken up on a case-by-case. No, they didn't have a bright line. I think what you're coming to as bright line might be very difficult. Is that what I'm hearing, or?
I don't think there is one.
Okay. So if you look at the definition we've come up with, the introduction to the definition is basically saying that these will be factors to be considered. Because, again, we weren't trying to create a bright line in our proposed rule. So then we have two factors which we will consider, and we will consider both of them to determine whether it goes in the review or not in the review. But we only get to this definition after you've already shown charged or sued with infringement. That's a pretty big hurdle because it's not, our understanding is about 3,000 litigations a year on patents. So we got a small universe of patents. Then you have to be a business method, which Congress has plainly defined for us. And after those two hurdles, we get to this last definition, which we understand people are going to be concerned about, and rightly so. We've had a lot of internal discussions. We'll have those two factors to look at. And we did find those. Those have been factors that have been advanced before. We found them. We thought they were interesting considerations to take into account. If there's other considerations you think should also be taken into account, we look forward to written comments on that point. Is that anything else before we go on to the next?
Best you can answer it. Like I said, it's Congress, it's not you.
Okay. So the next question was on derivation, and I thought we started off with under 102. There's basically we're now looking at everything in the world, and you're asking, is there a way to compel evidence or testimony during one of our proceedings in general, or just?
Well, those that you're talking here about PGR and derivation.
Yeah, certainly we would consider that, but the party would have to move for that. They would have to request it. So they would call a judge and say, hey, I would like to compel testimony from third party or from other documents that are out there that we need. And the parties can all along agree to discovery amongst themselves.
Yeah, but what jurisdictions would you have to compel testimony from abroad?
If I may direct your attention at 35 U.S.C. 23 and 24, that does give provision that the office in a contested case proceeding, which again, these are contested cases, they're inter-party. We can then have a party go to before district court who would then have a subpoena put out. So it's not direct, we would issue a subpoena ourselves, but we would authorize going to the district court to get the subpoena.
That's the missing part.
Okay.
Appreciate it.
Great.
And my third part was, I haven't had an opportunity to ask, I'll ask now, is related to the timing as to when derivation will be entertained. And you said that the rules will provide that only upon issuance of the contested patent will there be that process. And so the catch-22 that the challenger might have is that he is also may have filed an application in the pipeline. And at that point, if a patent issues, unlike interference that allows the two parties to essentially deal with it through the prosecution on both sides, there will be an event of an issue of a patent that is challenged, that is now going to be, suppose it's not even published, so that would be the first time you actually see the patent. There won't be an opportunity for the challenger because his own patent will be essentially invalidated based on the filing date of the earlier application. So that tension is not resolved with this rule, and that's what I was asking.
Well, a derivation proceeding does not necessarily have to occur between an applicant and a patentee. It could be between two applications.
I agree, but you're saying you will withhold instituting the proceeding until it issues rather than the existence of an application itself. But, so you're deferring the resolution of the dispute to potentially years or two down the line, and the question still remains, and the challenger doesn't have a resolution and cannot pursue his own application.
If I could, I just want to, I think what we're trying to say is there's no specific rule on this point. What we're saying is what is likely to happen, or it's a possibility to happen. And the reason we put that in the slides is there's a provision in the statute, 135C, which I'd like to direct your attention to, that states deferral of decision. And we can defer a decision on whether to institute a derivation until the earlier application is issued as a patent. And that's all we're trying to capture there. Congress has already told us that we can defer.
Okay.
Does that help clarify?
Okay. Yeah. But another question, what happens with applications that haven't been published? So but that's probably a problem with statute. But if you have the authority to do it earlier, you could.
Yes. And it's something that'll be taken up in the specifics of the case.
Thank you.
Thank you.
Another question from our live audience.
My name is Val Tran. I'm with Power Patent Inc., and I have the same follow-up questions on the CEM on what is technological invention. when I read the definition, it reminds me vaguely of a European Patent Office determination of Section 101 equivalent. And so I was wondering whether or not you look at that and you can be using that as kind of a guideline as to what is quote unquote a technological invention.
We've studied many sources, and yes, we have seen the European office struggle with similar type considerations, and so we're cognizant of what they're trying to do on it. And again, we're trying ourselves to come up with our own definition under our own laws. But I'll just say it plainly, we did consider what they've done and looked at it. Of course, if you have insights on how you think it's better over there or how it could be done better here, we do encourage written comments. And if you have ideas, please let us.
I've read them, and I think that's just equally as confusing.
Thank you.
We have a question from our live audience following up on this conversation. It's from Derek Jennings, who is an IP patent agent for IBM. The question follows on. If the claimed invention is determined to be a technological invention, will a party be barred from both a post-grant review and an inter-parties review? I'll repeat the question.
Thank you.
So, if the claimed invention is determined to be a technological invention, can a party bring either an inter-parties review or a post-grant review? We're not talking a covered business method review. I take the question to mean, can they separately bring an inter-parties review or a post-grant review?
The answer there, it's yes, but again, because Congress, these are a little bit more detailed statutes, there's always a caveat. And so I want to go, what the question is providing is, if we don't institute a transitional program for covered business method patent, that's why I say CBM. If we don't institute a CBM review, there would be no final written decision. If there's no final written decision, there's no estoppel provision against the requester. Now, however, there are provisions that in 325D, in the post-grant they put it in, that states that we can consider prior arguments of unpatentability against a patent. So if it was solely on the argument that it was not a technological invention, we didn't proceed, then that wouldn't go to the patentability issue necessarily. But if there were arguments in a CBM, I'm just trying to point out, where we didn't proceed because they hadn't made out a case of unpatentability, then those arguments, if they were just merely repeated in the form of a PGR and IPR, could be taken into account.
And a follow-on question for Mr. Jennings is, does the office plan to define the terms technological feature, technical problem, or technical solution? It's similar to what you asked.
We look forward to written comments and suggestions.
Yes, sir. Question from our live audience.
Unfortunately, you're going to be dealing with another Jennings, but I'm not Derek. I'm Earl. I mentioned this morning I was a patent agent. I also work as an executive in several companies and do their patent management. One of the things that small startup companies here and elsewhere in the world face is the potential for litigation by deep-pocket, much larger entities. What you guys have put together looks fantastic to the small business people. What I would like to ask you is to consider adding to your list of potential petitionees small entities who say, hey, look, we've just gotten clobbered in Chicago with litigation that's going to cost us gazillions of dollars, take forever to get done. Please, oh, please, oh, please, Patent and Trademark Office, let's come to you. Let's get through this nonsense in a year and go back to business. Thank you.
Thank you for your comment. Other questions or comments from our live audience or our webcast audience? Yes, sir. Please come to the microphone.
Yes, Phil Wadsworth from Qualcomm. Thanks for coming today and sharing the details with us. Back on technological invention again. Director Capo. Now, I understand the statute creates kind of a conundrum in that area for you. But and being familiar with the legislative history, I'm not so sure that it necessarily requires the first prong of the test, which is a technical feature that's novel and unobviousness. You know, number one, I don't think there was an obviousness component discussed in any of the legislative history. And I think it would be more helpful and efficient for the office and for the board if you would not have to do a preliminary patentability test of a technical feature. And it seems a little inconsistent to have the preamble say that it's, you know, taking the claim as a whole, but then we're going to look at a technical feature within that claim, and it's almost like a point of novelty and point of obviousness test for one element of the claim. So I don't know how you'd really execute on that well. So, you know, another thought that has come out through the legislative history as well, I think, is this notion, are we dealing with an application of science, engineering, or mathematics? And maybe that would be a more palatable first prong of the test, and then the European-like second test. So, because I'm fearful if you do the patentability test in the technical invention part too, then that could have some unintended consequences on enforceability of that claim down the road outside of the context of this type of proceeding. So, thank you.
Scrap the first prong of the test.
Yeah.
That's just a big one.
And possibly replace it with more of a subjective, I guess, test that would be, are we looking at application of science, engineering, mathematics, that type of thing too. So that seems to be more useful for a case-by-case analysis.
I just want to say that obviously we're having a lively discussion on this, and not giving away anything that happened in-house, but there were a lot of lively discussions inside the patent office among everybody on how to try and define this properly. And you can tell, I'll just tell you, it's been a struggle to find this just right. We put out a proposed rule, and we're looking forward to getting these comments. And if you could please provide them in writing also, so that we can have it for the full everyone to see. We're getting a lot of good suggestions, and we want to be able to find, again, we're trying to just find a balance here. And I think on this one issue in particular, it's a difficult one.
Thank you. Other questions, comments from either live or webcast audience? I have a question about the real party in interest as it relates to the estoppel standard. How is the Patent Office going to interpret the term real party in interest for who can bring a post-grant review, and then subsequently who will be stopped from bringing a subsequent one?
Well, again, it's going to be case-by-case basis that we will look at the district court law and look at the factors that they've come up with. So, for example, control might be one of the factors we look at, but there's no one exhaustive list. And they have repeatedly told us that there's no one exhaustive list of elements. So it will be on a case-by-case basis.
If a patent owner wants to challenge the real party in interest identification, does the board have a process for bringing such a challenge? How will you handle it?
Well, again, as I said earlier, the judge will be assigned to the case from the very beginning once the petition is docketed. So you would call the judge and you would have a conference call, and this would come out probably through a motion. So the party would file a motion, or they would include it in their response. And if they needed additional evidence, then we would likely grant a request.
And just to follow up, it also could just be as simple as having a conference call. If enough facts are established that we know we need additional information from the petitioner as to why there may be enough sufficient questions raised during a conference call to go forward and start making an inquiry on the petitioner. And at the point where we have so much information that we have to go and possibly have that discovery, it's possible to decide it on the phone, or, as you say, get some quick discovery up front, because the last thing we want to do is institute a trial where we never should have had a trial. So that's one of those exceptions we say where we would actually want potentially limited discovery up front so that you're not having a trial that was never meant to be.
Other questions from the audience? Commentary? Yes, sir. Please come to the microphone.
Just on that last point again, I think the rules were saying that as a general rule, the patentee cannot include testimonial evidence in their response to the petition. But I would think under KSR, when there's always a 103 type of challenge, that would probably be accompanied by an affidavit from the petitioner, and that would necessarily, I would think, always result in allowing the patent holder to use testimonial evidence of an expert on, the skill, who's skilled in the art or level of skill in the art, and that type of thing. Is that a fair assumption?
You're correct, that we would want to hear from the patent owner to have a rebuttal expert, but the time for that would be in the patent owner response. And we'll go into that. Up front, we're having just a preliminary response, and that's, is there some defect in the petition that we need to be aware of? If it's getting down to a battle of experts, my expert's more credible than your expert because my expert knows the art better or has interpreted the test data better, then we're starting to get into a credibility determination where we really do want to see the discovery then. So we want to have that more, the credibility battles with this full discovery in the trial portion. We envision the preliminary response being just a preliminary. So you're right, in a 103, you can always respond to 103 like an ex parte prosecution, where you don't necessarily need an affidavit from an expert to show the examiner was incorrect. But in those instances, in those close calls where you might want to have an expert come in, that's where the petitioner is probably wanting to take discovery, get some cross-examination, and we felt that was best when we have the full-blown trial. And we didn't want to have a full-blown trial followed by a full-blown trial. That would be against the congressional intent.
Yes, sir. Please come to the podium.
Yes, Darren Allen with International Friendship Bands. I was wanting to ask under 35 U.S.C. 2, Section 2, the powers and duties, and the Secretary of Commerce, where does it fall special relief and special handling, and at what point does the morale and duty of the representative, the attorney, or the ability for the patentee or patentor to be able to receive that if they are set in a segment of disaster, international, or a disabled, disadvantaged individual, and the costs that are becoming unavailable or unattachable to a disabled person that might be set or on a fixed income.
If I could maybe rephrase your question to make sure we understood. Are you asking about the authority for the Patent Office to conduct these trial-type proceedings?
Well, it seems as though that we had post and pre-applicants. We had post being that they were a patentee owner, and we had pre being pre-applicant, and there was segments of time and then an examination process. Now, we had a Sanumi, or we had some other altercations down in New Orleans, and not inclusive to other areas where we had some problems, maybe a mail of documents that goes under conditional and unconditional, conditional or unconditional, excuse me, I don't mean to be corrected. That would be under a petition for abandonment. It's going to be under unconditional or conditional. And I didn't mean to get 35 involved. But it seems as though there are some good understandings where the chief executive or the conference with being able to produce jobs, because we were here with jobs today in front of Congress. We do need jobs in the United States of America. Where does a person that's disabled or disadvantaged, it almost seems where Hillary and Bill Clinton, where they had it, the person could just be set aside in society so that you guys can make it, or not to be to place anything on somebody, where it could be set aside where it becomes public domain and someone could just take it. And I didn't mean the mean, mode, or average of that.
Right. Thank you. I think we understand your question much better now. So I believe that the point here being made is that these proceedings are available to any patent holder who obtains a patent after going through full prosecution with the Patent Office. Disabled, not disabled, they're available to any patent owner in any type of situation. as long as they file a third party can challenge them in such type of situation. Well, the relief that would be available in these type of proceedings is that the claims that are challenged, if the board determines that they are unpatentable for a certain reason, then those claims would be rejected out of the patent. We will talk about the detailed cost for these type of proceedings in the next session, so I'd ask you to hold your question until that point in time. Do we have other questions or comments from our live or webcast audience? Well, at this point, let's take our afternoon break for 15 minutes, and we will come back at 3 o'clock to talk about the umbrella rules, which are like the rules of civil procedure for the trial proceedings. So back in 15 minutes.